Welcome everyone. In this session, we are going to learn about meetings. So, different kinds of meetings in corporate law. So, what is the importance of all these meetings? Everything we'll discuss in this session. So, yeah. So, there are different kinds of meetings under Companies Act 2013. So, the meetings under Companies Act can be classified into different types. Like the first one is shareholder meeting. The second one is meeting of debenture holders. Third, sorry, holders. And third one is meeting of creditors. And contributors. Then the fourth one is the the board meeting of board of directors. And the fifth one is meetings of the board committee. All right. So every company must hold annual general meeting in every calendar year. So the gap between two annual general meeting can never exceed 15 months. So here these are the different types of meeting which I have said, like a shareholders meeting, meeting of a debenture holders, meeting of a creditors and contributors, that is meeting of a board of directors and meeting of a company. So shareholders have a meeting called as a annual general meeting. Shareholders meeting having a meeting they will hold. It is called as a annual AGM, general meeting, as per section 96. Section 96. And they may also organize another meeting called a extraordinary general meeting. Extraordinary general meeting. So, extraordinary general meeting can be convened by directors, convened by directors on the requisition of a shareholders under section 100. So, same like debenture holders can also have meetings, but it is not like annual general meeting or extraordinary meeting. They can hold a meeting. All right. So, meetings of creditors and contributors. Meetings of creditors and contributors is another meeting, and it has a meeting of a creditor for the purpose other than winding up. Like who is creditor and contributors? Creditors and contributors, maybe banks or financial institutions, are called as creditors and contributors. They can have a casual meeting. It is not for the purpose of winding up. Meeting of Next is meeting of creditors for winding up, and meetings of contributors at the time of winding up. So both can conduct a meeting, a casual meeting which is not for winding up, and they can only hold other meetings only at the time of before the time of winding up. So let's discuss one by one. Let's go ahead to first we can discuss about annual general meeting. So what exactly annual general meeting? So annual general meeting then is meeting should be held once in a year, AGM. So annual general meeting will conduct once in a year. Okay, and the first annual general meeting of a company should be held within 9 months from the closing of the first financial year. From the closing of the first financial year. Hence, it shall not be necessary for the company to hold an annual general meeting in the year of its incorporation, but it has to hold an annual general meeting within 9 months of a first financial year. First, okay. So there is no issue if a company is company has commenced and it is not holding an annual general meeting before its first financial year. The third one is subsequent annual general meeting should be held within 6 months from the closing of the financial year. Subsequent annual general meeting should be held within 6 months from the closing of the financial year. That means the first meeting should be within 9 months of the financial year, and the second, that means what exactly? If it is March, it is March, right? So next financial year is 22 23. So 22 23. So I'm starting a company right now. Okay, and I have to do a annual general meeting within from April, within November or October. So within 9 months, April to October. This is the right time if I'm starting a company today. Okay, but what about a company is getting older and has got a 1 year? So the subsequent annual general meeting should be within 6 months of the financial year, every financial year. Okay, within 6 months. So the subsequent annual meeting should be 6 months in the sense like from the closing of the financial year. Okay, from the closing of the financial year. That means, have an example. Um, March 31st. So again, within 6 months is April, May, June, July, August, September. Yeah, September. Within September, I have to start September. I have to conduct a annual general meeting if my company has crossed 1 year. Next is the gap between two annual general meeting should not exceed 50 months. Should not exceed 15 months. All right. So in the case, actually extension of valid period of annual general meeting. So annual general meeting within the prescribed time, the registrar may, for a special reason, extend the time within which any annual general meeting shall be held. Such extension can be a period of 3 months. So there is a period of 3 months grace period with the permission of registrar of company can be obtained. Can be obtained. This is an exception. Okay. This is an exception. So next is extraordinary general meeting. So what exactly extraordinary general meeting? So all general meeting other than AGM are called extraordinary general meeting. General meetings, all general meetings other than annual general meeting is called as a extraordinary general meeting. In the name itself, we can see extraordinary. Extraordinary. So EGM of a company, extraordinary general meeting of a company, other than the wholly actually owned subsidiary of a company incorporated outside India, shall be held at a place within India. So if it is a company which is not wholly uh, owned and which is operating outside, should not need to hold a general meeting in India, but a company other than of the wholly owned subsidiary of a company, subsidiary company of Indian subsidiary company incorporated outside India, shall be held at a place within India. A company which is registered in India and a subsidiary company is holding outside India, okay, not fully owned, but have to have a extraordinary general meeting. If they are going for extraordinary general meeting, they have to come to India and hold the general meeting. Okay. One second. So all business items can be transacted at the extraordinary general meeting are special business. Okay, special business like a board, whenever it deems fit, call an extraordinary general meeting of a company by a board. Extraordinary general meeting can be held by a board or board of directors. Okay, if there is a reason, there should be a reason, or it should be deems fit, can call a extraordinary general meeting. So by a board on requisition, requisition means some uh, you know certain uh, requirements. Okay, that is called as a requisition. Board on requisites. Requisition. So the board must call an extraordinary general meeting on the receipt of the requisition. Okay, requirements which is requested by certain members in case of a company having share capital. So member who hold on the date of the receipt of the requisition not less than 1/10th of the paid up capital of the company as on the date carries the right of a voting. So who can give a request? Like a shareholder having 1/10th, or shareholders who having 1/10th of share of a company and having a voting right. And in case of a company not having a share capital, members who have on the date of receipt of the requisition not less than 1 by 10th of the total voting power of all the members having on the said date a right to vote. So the requisition should set out the matters to be considered at the proposed meeting, and the same should be signed by the requisitionist and sent to the registrar of the company. So it can be done in the case of a company not having share capital. Okay, so this is also having 1 by 10th voting right is there in the company having share capital also. Here share capital, here the company doesn't have a share capital, and the members who have on the date of receipt of requisition not less than 1 by 10th of the voting right, those as per the request of those people, the board can hold a you know um, extraordinary general meeting. So extraordinary general meeting has to take very urgent decisions, decisions like removal of a director, then some winding up of a company, then have to take some very fast decisions. Next is statutory meeting. Next one is statutory meeting. What is statutory meeting? Every public company, sorry, every public company having share capital must convene a general meeting of shareholders within a period of not less than 1 month and not more than 6 months after the date on which it is authorized to commence its business. So, if a business who complete its registration with the registrar of a company within 1 month, they have to hold a statutory meeting of a shareholders. Okay, so statutory meeting can be done before the annual general meeting. So statutory meeting, so it is only for the public company. It is only for the public company to hold a statutory general meeting having a share capital should have to hold a general meeting of a shareholders. Okay, shareholders. So within a period of not less than 1 month and not more than 6 months. Okay, not more than 6 months. All right. So when the commencement, from the date of commencement of a business, so within 1 month and not more than 6 months. Okay, not less than 1 month and not more than 6 months. So that is what exactly statutory meeting. So this is the first meeting of the shareholders of a company, and it is held once in the whole life of a company. Okay, this meeting is non-recurring. It is only one and only uh, whole life, one and only meeting, which will commence in the whole life of a company. All right, statutory meeting. So next thing, you need not want to learn that, but see, um, notice of a company. So sorry, notice of a meeting. How to distribute notice? Notice in the sense like we have to make everyone aware about you know the meeting. So the directors have to put the notice, to send notice of the meeting to all the members within 21 days. Within 21 days before the date of the meeting, stating that it is the statutory meeting of the company. Okay, so the directors has to give notice to the shareholders within 20, 21 days of notice. Okay, 21 days before the date of meeting. So they have to give a date of notice before 21 days before the commencement of the first statutory meeting. Okay. So if the notice conveying this meeting does not name it as the statutory meeting, it will not amount to compliance with the provision of the section. So the notice should mention it is statutory or company's statutory meeting. Company's statutory meeting. So what is the objective of a statutory meeting? So actually the statutory meeting is held to inform. Okay, inform the shareholders. Inform the shareholders about the matter relating to incorporation. Okay, allotment of shares. So the details of the contracts concluded by the company, etc. So according to the laws, the statutory meeting is convened in order to accord the shareholders an opportunity for seeing what degree of success has attained the floating of a company, and in order that any special matter requiring their approval may be laid before them. So statutory meeting is, it's a mandatory thing. Once the company is get commenced, within 1 month, between 1 month and 6 months, the statutory meeting should have to be held. And statutory meeting is for informing the shareholders about the matter relating to the incorporation. Incorporation of a company. All right. And there shall be a statutory report. What do you mean by statute? Statute means law. Okay, as per law. Statute means law. Statutory means legal. Okay, legal. So there shall be a statutory report also. So the directors are required to prepare and send a report called statutory report to every member of the company at least 21 days before the date of a meeting. Prepared by the directors or board of directors before 21 days of the meeting. Okay, it is a report. So if the report is sent later, it shall be deemed to have been duly forwarded if it is so agreed to by a unanimous vote of the members entitled to attend and vote at the meeting. So a copy of this report should be sent to the registrar also. So if a copy, a copy shall be sent to the to the shareholders. If the shareholders would get a copy, then consider that shareholders will get a voting right. It is implied. If a statutory report, so those shareholders are 1/10 of share capital, holding share capital. Okay, and they having a voting Right. All right. So we learned about annual general meeting. Let me conclude. Uh, Let me sum up with some brief idea about the meeting. So you will get a short answer question maybe. So the word meeting is actually not defined in Companies Act 2013. But we can say like a company may be defined it as like a gathering. Okay, meeting is what exactly? Gathering, assembling, or coming together of a two or more persons. For what? For playing chess? No, for discussion and transactions of some lawful business. Okay, so a company meeting may be defined as a concurrence or coming together of the at least quorum of members in order to transact either ordinary or a special business of a business or of the company. So, what is the characteristics of a company meeting? What are the characteristics of a company meeting? Let me discuss that also. So, there shall be of a company meeting. There shall be two or more persons who are the members of the company must be present at the meeting. Otherwise, I cannot hold a meeting. Board of directors cannot hold a statutory alone can hold a statutory or annual general meeting. So the assembly of person must be for discussion, not for a booze party. Okay, it is for discussion and transaction of ideas of what? Lawful business. Okay, and the third is like a notice should be provided. How many days? 21 days before. Okay, meeting must be held at a particular place and date should be early mentioned before 21 days. Particular place, date, time should be mentioned. The meeting must be held as per provision or rules of Companies Act. Okay, provision or rules of a Companies Act. So, as per the Companies Act 2013 only, we can hold a meeting. Otherwise, if you hold a meeting and it is not minuting, definitely that meeting is called as, you know, a illegal meeting. Okay, illegal meeting or a casual meeting, something like that. So there are meetings. What are the different kinds of meetings? So shareholders meeting, meeting of debenture holders, meeting of creditors, board meetings of a board of directors, meetings of a board and committee, and we can divide it into statutory general meeting, annual general meeting, extraordinary general meeting. And meeting of directors can be like a meeting of board of directors, meeting of creditors, meeting of debenture holders. Okay. So In a nutshell, I can divide it into like this. Meeting, meeting, meeting of shareholders, meeting of directors. Okay. So meeting of shareholders can be say like a statutory, then AGM, annual general meeting, and extraordinary general meeting. Meeting of directors can be board of directors meeting, then directors meeting, then creditors and debenture holders meeting. All right. So this is the end of our session. Thank you so much.